Initially, I thought this was a normal custody agreement. It was a little interesting because dad and mom were kind of equal, and how do you decide who gets the kid when it's equal? But then they started talking about taxes and things like that, and dad's understanding of what happens in a custody agreement kind of got me. Plus, it's Judge Ricky, and I'm always down to watch Judge Ricky. How about you? So, enjoy.
This is in the District Court of Butler County, Kansas, case entitled in the matter of the paternity of W.W., a minor child, by and through parent Aaron Leanne Moore and Scott Wesley Watkins. It's case number 2020 DM 304. Susan Locke appears as counsel for Aaron Leanne Moore, who appears in the office of her attorney by Zoom. Scott Watkins appears by separate Zoom. This matter comes before the court for further proceedings in regards to a motion to modify residency and parenting time and for other relief. Mr. Watkins, I'm aware of what the movement is asking for here. Are you opposing any part of this motion?
Yes.
Okay, what are you opposing?
Pretty much all of it, Your Honor.
All right. Then let's review what that means. Ms. Locke,
Okay.
What exactly is your client seeking here? Let's talk about what the existing parenting plan is and how you're trying to change it.
Sure, Your Honor. And just for the record purposes, my client's husband is present in my office as well. He's just not on the camera. We are asking that residency and parenting time be modified. The current ordered parenting time is a week on, week off. However, the parties by agreement, when the child's name is Wyatt, when Wyatt started school, the parties agreed that Mr. Watkins would exercise parenting time during the school week, and the child would attend school at USD 490. And then my client mom had every weekend. We are requesting that mom become essentially the school parent. Even though she lives in Greenwood County, she's committed to making sure that Wyatt attends school regularly and maintaining his current school district of USD 490. The concern is that frequently and more frequently over the last 4 months, she has had to be the school transportation for Wyatt. This is very difficult to be happening on a sporadic basis. Mr. Watkins, we understand that his adult daughter used to live with him, and once she moved out, consistency in transportation became very difficult. And there's been frequent times where the school has called my client and said, the child's still here, no one's come to pick him up. Is someone planning to pick him up? And it's my client that has picked up those pieces. So we're asking that for consistency purposes, she become the school parent. She's committed, like I said, to making sure he has transportation to and from school, maintaining that regular schedule, maintaining the evening schedule to allow for homework, regular childcare after school, all of that to be maintained. It's not clear exactly how that's being maintained in father's home. There's been many late assignments. There's been many days where he's been absent or tardy or again, not picked up. And we think that consistency is very important. In exchange for that, where mom had every weekend, dad would have every other weekend, with mom's Saturday work to be offered first to dad. So if she's coming to El Dorado on a Saturday, she would offer that time to dad so that he can exercise that parenting time, additional parenting time, in addition to the every other weekend.
Okay, well, I saw from the file that your client previously lived in, I think Montgomery County, when one of these parenting plans were established, and now she's moved to Eureka. Is she not stable in one residence? Yeah, because if we're going to change school residency, consistency is important for the child. And if she's going to keep moving around, that's an issue. Mr. Watkins, where'd you go?
We've been there for a year.
I was
Let's
gonna
get
wait
Scott
for
back
Scott until
on.
he was back. Okay.
Mr. Watkins, you disappeared on me for a moment.
I do apologize. I don't know what happened there.
Okay,
Your Honor, when my client first got married to her now husband, he was working on a ranch in Elk City, Kansas. They have since returned to essentially his homestead in Greenwood County. They've been living there for 3 years and anticipate that it will be their lifetime home.
all right. Mr. Watkins, why are you opposing this motion?
They are correct in saying that at a certain point in time, my adult daughter did live with me. She was the primary caregiver when I was at work. She did move out unexpectedly, which put me in a pretty rough position. Ambulance, I apologize. So I did go through a little bit of a rough patch with childcare and transportation. Absolutely. I got that figured out. My vehicle situation at the time was a little rough also, so there was just a lot of issues. I had asked Miss Moore for assistance. She had been picking him up, dropping him off, whatever, from school for about approximately a month. And then she had some issues at work. She had to back off from doing that, and it become my responsibility. I mean, I can pull up the chat logs because I've kept it all, but towards the end of the school year, the transportation issue, who I had picking him up, I don't know what was going on with them. I don't know, but their communication stopped. It wasn't always her. I picked him up several times. If he was sick, it wasn't according to the motion that it all fell on her. I got several phone calls when he was either sick or, they did communicate with me that they couldn't pick him up or drop him off. I did several times within the last approximately 2 months of school. I have given him very steady home. I think part of it says that, basically I do no meaningful activities, although almost on a daily basis, as long as the weather is nice, we go do something every day, be it a park. We live close to the pool, the lake. I had to go buy a bicycle so I can keep up with him riding his bike. We do something every day that he enjoys, and it expands his mind. There's been no point in time where beyond like a 10-minute wait because no communication with his transportation to and from school that he's been left alone.
All right, but you don't necessarily take him to work, or excuse me, to school every day?
Not every day, no. But I did the last month and a half, I took him all except for 7 days.
All right.
My work allowed that. And I can't remember, I don't have my notes right on top of me how many days that I picked him up. But it was several.
Well, we appear to have a bona fide dispute here, Ms. Luck. The court is going to need to hear evidence more than just the statements made here today by the parties to make a determination of the best interest of the child for the upcoming school year. We're not under extreme time pressure, but we do need to get this heard before the start of the next school year, which I presume will be around mid-August. Is that right?
I believe so.
I think it's the 14th or 15th, Your Honor, yes.
Mr. Watkins, do you intend to get an attorney to represent you on this?
I do not.
All right.
I'm financially unavailable.
I'm reasonably confident I could hear this in a half a day. I'm looking at the afternoon of Thursday, August 8th. Ms. Locke, your availability at that time?
I'm available, Your Honor.
All right. I'm going to set this for an in-person proceeding in courtroom B in El Dorado for 1:15 p.m. on Thursday, August the 8th. Each party can present their case at that time. I will require the parties to exchange any exhibits. In other words, any documents that you believe the court should consider. They need to exchange with each other at least by the day before, August the 7th. Actually, I'm going to back that up a little bit. I'm going to require the parties to have all of their documents to the opposing party by Monday, August 5. I'm not requiring anybody to produce documents, but if you intend to have any type of pictorial or documentary exhibit, you need to make sure that that's been shared with the opposing party, presumably by email. And I trust you have Mr. Watkins' email address, Ms. Locke?
I believe I do, Your Honor.
Okay. You need to have that to the opposing party by Monday, August the 5th. As a prelude to our hearing, the afternoon of Thursday, August 8th, starting at 1:15 p.m. I know that's cutting it close as far as enrollment and the start of the school year in either district. But that's the date that's available, and that's a week ahead of, I think, or at least the week before most schools are going to start.
And Your Honor, we don't anticipate that he would change school districts.
All right.
He's already in.
Despite the fact that he would live in Eureka, he would still go to school in 490 in El Dorado?
Yes.
Correct, Your Honor. My client comes to El Dorado daily for work.
That's good. All right. So Thursday, August 8th, 1:15 p.m. Now, I want to address the other issue that was raised here, and that is involving tax exemption claiming, apparently, which is
Yes.
referred to in the paperwork as tax deductions. I'm trusting, Ms. Locke, that we're relying on a parenting plan provision that was filed October 6th of 2020. And that would be paragraph 13.
Your Honor, oh, we lost Mr. Watkins there for a second. There was an amended parenting plan that was filed on June 23rd of 2021 that did impact the tax.
Okay, paragraph 13 of, well, it's paragraph 4 of that document, which refers to paragraph 13.
Yes, Your Honor. The reason for that change was this happened previously where Mr. Watkins claimed the child on his tax return on a year that we understood that Miss.
Okay, where'd he go?
Yeah.
Scott Watkins? We keep losing you.
Yes, Your Honor.
Okay, we're discussing this tax.
Yeah, I don't know what's going on. I
Okay. All right, Ms. Locke, you said that previously Mr. Watkins had claimed the exemption in the wrong year. So it was
Correct.
reversed. The original provision was reversed, where your client would claim the minor child as a dependent on her tax return for even tax years. Now, tax years isn't defined in any way. I am presuming that the parties intended that a tax year be the year for which income is earned and a tax return is filed for.
Correct. And my client claims the child in the odd tax years. So this would have been her tax year to claim the child. And when she filed, her return was rejected because Mr. Watkins had already filed and claimed the child for the second year in a row.
Okay. All right, Mr. Watkins, again, I presume you knew that a tax year means the year for which income is earned and which you're filing a tax return for. And you're claiming the child during odd years as well as even years? Despite the fact that you've agreed otherwise?
It was not originally intended to be that way, Your Honor. That was a mix-up with my tax agent.
Well, okay, it's your responsibility to control your own tax return, which you sign and you submit. So I'm not going to put this on your tax person. You agreed that you would only claim the child as a dependent for certain years. Did you file an amended return once you realized that a mistake had been made?
No, not yet, Your Honor.
And I see you at least have an electronic signature on the amending document. So I'm presupposing that you really did approve that change. Okay, so what is your position regarding the request for some financial relief because you claimed an exemption which you had agreed not to claim?
At this point in time, it's verifiable that according to our parenting agreement, it is 50-50 parenting time. Now, it is verifiable that I have our child far and above that 50% mark. So at this point in time, being above that 50-50 parenting time gives me every right to claim him because our parenting agreement failed once I passed that 50% mark. Regardless of what that parenting agreement says, once one of us goes up and beyond that 50% mark, that person can claim him on their taxes.
All right, Mr. Watkins, I'm not here to construe federal law. This court doesn't allocate tax exemptions. It is my opinion that is governed by federal law, not state law. And therefore, this court isn't responsible, nor does it want to take on the responsibility of trying to determine between you and IRS who gets to claim an exemption. That's what you're arguing. What I'm here to do is to enforce the parties' agreements. And you agreed originally and then agreed to change a provision that you and the mother of the child agreed to regarding allocation of exemptions. And it's that agreement that the court is here to enforce in accordance with its terms. I don't get into whether that agreement should be in effect or not. I'm here to enforce what's on paper. And you agreed when there was this modified parenting plan to share the exemption so that there would be no adjustment to the child support worksheet. Whether you should agree to that or not is a separate question. What IRS would construe your situation to be is not the question before the court. It is whether there's an agreement in place to share exemptions, and if there is, the court intends to enforce it. You agreed that during for odd tax years, the petitioner will claim the minor child as a dependent on her tax return. She has every right to rely on an agreement that she made and you made. And you haven't filed anything to correct any improper claiming of the exemption, so I'm going to presuppose at this point that you're not going to. Or you would have done it by now. But one of these refers to 2021 return. Does it not, Ms. Locke? The other 2023?
Correct, and we're only asking for damages associated with the 2023 return.
And what amount are you seeking?
It's slightly modified from what's in our motion because my client received more than anticipated in her state return. So that amount, amended amount, is $7,126.
Okay. Back up a minute. As I understand, you were seeking the difference.
Oh, I apologize, Your Honor. Yep, that's.
Are you talking about, okay, go ahead. What's the new difference between whether she got to claim the exemption on federal estate and if she didn't get to claim?
Sorry, we're asking for $3,746.
All right. That's a number that makes more sense under the circumstances. All right, Mr. Watkins, I'll give you the floor again. Do you have any additional arguments or remarks to make in that regard?
Other than I agreed to the parenting agreement based on the fact, or I do apologize, the tax return, the tax exemption. I agreed to that at the 50% marker, the 50-50 parenting time marker. So beyond that, that is why I have not filed an amendment yet. I would have, but Miss Moore decided to come to court instead. I would have done this amicably and easily, but she didn't give me an opportunity. So at this point in time, I agreed to the parenting agreement and the provision with the tax returns that we maintain the 50-50% marker. Verifiably, I have him over that 50% mark, which completely throws out that part of the parenting agreement and the amendment.
Did you get the court order change or get her to sign a new agreement to that effect?
No, I did not.
Well, I think you're under some impression, Mr. Watkins, that you can unilaterally just declare that the provisions that are in effect are no longer operable and you don't have to follow them anymore. But that's not fair to the mother of this child. She has every right to rely on what the state of the agreement is in filing her own tax returns. And I can see it makes a substantial difference to her whether she gets to claim Wyatt as an exemption or not. According to the figures before the court, which the court at this point has no reason to dispute, $3,746 with the difference. And I'm sure it made a substantial impact on your tax return and probably allowed you to come out in a much better position than you would have if you had not claimed Wyatt as an exemption for that year. Again, the court's jurisdiction here is to enforce the agreement that's in place. And the agreement in place said you weren't supposed to claim Wyatt. And you don't get to just unilaterally decide you're just not going to follow it. And so I am going to grant a judgment in favor of Aaron Leon Moore versus Scott Wesley Watkins in the amount of $3,746 as compensation for that provision not being followed that both parties had agreed to and was essentially approved by the court as part of an overall parenting plan adjustment. Finding that she suffered damages in that amount. Further, the court will expect that the parties will follow their agreement regarding sharing of the exemptions to avoid future problems. Now, a parent can always voluntarily sign it away. The parents can get together and reach a different accord when it comes to sharing of exemption benefits, but until then, the court will enforce the provision which is in effect. Ms. Locke, I trust you'll draft an appropriate order which grants that judgment.
Yes, Your Honor, if the court's okay, we'll also include the continuance for hearing.
Yes, you may combine that in one order. Right, were there any other issues that were raised by your motion that haven't already been set for hearing or ruled upon by the court, Ms. Locke?
No, Your Honor.
All right, Mr. Watkins, anything else that we need to address currently?
No, Your Honor.
Okay, then just understand that you'll need to be there in person. It's my understanding you'll be representing yourself at the hearing in courtroom B, Butler County Judicial Center, Thursday, August 8th, 1:15 p.m. for further proceedings on the motion to modify the parenting plan in the case. If there's nothing further, the Moore and Watkins matter will currently be in recess, and this meeting may be ended for all at this time.